Now I am going to dictate a legal passage at the rate of 160 words per minute based on Supreme Court judgment. Let's start. The trial court, without any previous sanction of the state government under Section 197 CRPC, took cognizance in respect of a charge that the appellant had in the purported discharge of his duties used to force in excess of what was necessary and thereby committed an offence. The High Court in appeal by the appellant, however, took the view that inasmuch as the state government itself had acquired sanction to prosecute the appellant in exercise of power under Section 132 of the CRPC, there was no need for or sanction under Section 197 of CRPC. Allowing the appeal to this court held the proceedings against the appellant must be quashed as lacking in jurisdiction. The court would not have taken cognizance of the offence, for there was no jurisdiction to do so in the absence of the requisite sanction. This order will not operate as an acquittal and merits, and the appellant can be proceeded again. It afresh whether or not to do so is for the competent authority to decide. Two safeguards are provided in regard to prosecution of members of the armed forces or of the forces charged with the maintenance of public order sought to be prosecuted for use of excessive force in the discharge or purported discharge of their duty. The first safeguard provided in Section 132 CRPC is that they cannot be prosecuted without obtaining a sanction to prosecute from the appropriate government, and the second safeguard is the one provided under Section 197 that no court can take cognizance of an offence against such an official in the absence of the previous sanction of the appropriate government. A sanction under Section 132 of the CRPC is no substitute for a sanction under Section 197 of the CRPC. Six significant points of difference need to be highlighted. The two sanctions are addressed to all together different persons, while sanction under Section 132 is addressed to the intending complainant. Sanction under Section 197 is addressed to the magistrate presiding over a court. The two sanctions serve to altogether different purposes, while the sanction under Section 132 clothes the intending complainant with authority to institute a complaint and set the machinery of the criminal court in motion. The sanction under Section 197 clothes the court with the jurisdiction to take cognizance of the offence without the former. The intending complainant cannot trigger the proceedings without the latter. The magistrate cannot have session over the matter or act in the matter. The absence of sanction in each case visit different persons with different consequences. Absence of the former disables the intending complainant, whereas absence of the latter disables the court. The disability operates in two different spheres. Want of sanction under Section 132 renders the complaint invalid. Want of sanction under Section 197 vitiates all the proceedings in the court. For want of the former, the complainant cannot complain. For want of the latter, the court cannot try the case. The sanctioning authority has to address itself to different questions in regard to sanction under Section 132 CRPC. The question to be answered is whether the intending complainant is a suitable person to be authorized for prosecuting the matter in good faith in regard to the sanction under Section 197. The question to be answered is which particular court should be empowered to try the case. So also in granting sanction under Section 197, the sanctioning authority has to consider whether or not to exercise the powers under Section 197 within Act 4 to specify the persons by whom, the manner in which, and the offence or offences for which the concerned public servant should be tried, and the court before which the trial is to be held. The authority seized of the matter in the context of sanction under Section 132 does not have to address himself to these questions, and in fact has no competence in this behalf. The judgment of the court was delivered by Thakur J. Can is sanction to prosecute surrogate. For a sanction to take cognizance, two safeguards are provided in regard to prosecution of members of the armed forces or of the forces charged with the maintenance of public order sought to be prosecuted for use of excessive force in the discharge of purported discharge of their duty. They cannot be prosecuted without obtaining a sanction to prosecute from the appropriate government. Government Sanction 1321 of the Code of Criminal Procedure within bracket CRPC within bracket 2. No court can take cognizance of an offence against such an official in the absence of the previous sanction of the 132 protection against prosecution for acts done under proceeding sections within bracket 1. No prosecution against any person for any act promoting to be done under section 129, section 139 or section 13 I shall be instituted in any criminal court except with the sanction of the central government where such a person is an offence or a member of the armed forces. Stop. Thank you.